My friend Dera Nevin is here. Dera is a true pioneer in the Canadian market. She was there when no one was listening. I don't know how she did it, along with a few others. Dera became an e-discovery lawyer and consultant before it really became a thing. And it's still very early days in our market, to the point that Dera now actually works in New York at the moment. But Dera is an expert on legal and technology, is sort of in the big data sort of space. And she can tell folks that are interested, if you're in the room and want to know what is the best way to build, are you building a pain reliever or a vitamin? Dera's the one that can get you there to tell you what is out there that needs to be served. And she also tells me, and I like this, she's going to be more unconference than I am. She's basically going to push conversation as opposed to stand and deliver.
Hi there. Am I on? Great. So my name is Dera Nevin. I'll give you a brief overview of who I am and why I'm here. And I think Jason's brought me in to give a bit of a different perspective on things because of my role in the ecosystem. So my name is Dera. I'm currently the director of e-discovery at Proskauer Rose, which is a firm in the United States. I have only recently moved there, so I went into the first 6 months there. Before that, I was based in Ontario. Jason and I have worked together a couple of times and also trained for a marathon together, so that's how we know each other. I came by e-discovery kind of honestly in that I started out my life as a graphic designer, believe it or not, doing all the handwork in the early 80s, moved into computer-assisted design, was one of the first people to actually implement computer-assisted design in the integration and four-color processing, eventually moved into graphical design when the graphical web came out, developed the whole process of taking a database, implementing it in a graphical web for internal or B2B communications, sold that, didn't know what to do with my life at that point, was in my late 20s. It was 1997, no idea what to do with my life. My best friend who I drank with said, I want to go to law school and be a lawyer. She couldn't get through the LSAT. I helped her through the LSAT and went, I could go to law school, and that's how that happened. I got into e-discovery, again, honestly, I was sitting in my fishbowl at Blake Castles in Graydon when a lawyer came into my office and he said, you're supposed to be smart with computers, you figure this out. It was a box full of 5.5-inch floppies. Right, and this is the late 90s. I was like, oh, that's interesting. So I went downstairs, realized that it was image and text associated files, and helped Blake's acquire the first automated litigation support application they had. And that pretty much sealed my fate, and I was still in law school. So as you know, when you practice law, if you do something once, you become the expert, and also then people come and bring stuff to you all the time. So now I keep on going into law firms and setting up the rediscovery operations. That's what I'm known for. I've been known for pioneering the use of so-called predictive coding, which is a term that I hate because it neither predicts nor does it code. It's kind of a silly term. But anyway, the application of machine learning. Really, I consider myself to be a multilingual search and visualization expert. That's really a data processing issue. And dealing with unconventional file types is really what I do. And really what I do is I'm very good at bringing order to chaos in terms of structuring data. And if you can think about that, that's actually one of the biggest pain points in law right now. And there are tremendous opportunities for true innovation in that field. So I think you've heard that both from Ken and both from Joshua. If you can figure out a new way to apply techniques to making sense of data, law is really a data field, and we're going to talk about that. So that's what I do, or that's what I'm known for. I actually consider myself to be a great mover of cheese. That's sort of how I refer to myself. So I consider myself to be a legal process re-engineer. And what I'm very good at figuring out is what can we stop doing to free up time to do things that are more useful. So I'll talk about the first 6 months in terms of what I did. The very first thing I did was look at a feed. So like most law firms, and you need to understand where value is trapped in law firms. In law firms, value is trapped in emails and in productivity files. That's where it's trapped. Value gets trapped there. So as we've said, you know, lawyers have divine inspiration. The divine inspiration becomes encoded in completely unsearchable and unmanageable documents. I used to be a litigator, but this is true for corporate lawyers as well. Where is the product that these guys deliver? It's in documents, it's in deals, it's in all kinds of stuff that over a catalog of them cannot be searched intelligently. That is the problem that almost every single law firm is wrestling with right now. From a sole practitioner to a large practitioner, the problem is law is now at a scale that is beyond the confines of human memory. So that's actually what you were talking about with the deals. The deals are now so complex, there's so many moving parts and so many jurisdictions that it's beyond the confines of moving memory. After all of my experience, and I've actually done metrics, so you guys, some of you have seen my enormous database, but I've now discovered that the approximate number of documents that a lawyer can store in human memory is just under 800. Okay, that's the break point that I've discovered based on all, like, because I record everything, I'm CDO. Some people call it OCD, but that's the wrong alphabetization, so I'm compulsively destined to organization, CDO. So that's a little bit about me. And you know, in my career as well, I have a career tallied production total of 500 million records. I stopped counting in December 2012 for 2 reasons. That's when I left McCarthy Tetro and took my hands off the document, so I had nothing to count. But you sort of get to a count number and you sort of realize, why am I counting this anymore? So I've stopped counting. I think when I got to 500 million, that's about it. Now, to get to a production total, because you know you're leaving a lot behind, I've literally reviewed or processed trillions of records. Just stop to think about that. That's kind of crazy. So that's why I really like to stop doing things. I'll give you one more anecdote about stopping doing things, and then we're going to talk about starting doing things that are very, very useful. So I went into Proskauer Rose, and here's the value that I brought right away. I always say, what's your value to an organization? It's total value of the organization minus total value without you, right? Very, very simple equation. If you want to know your value to the organization, you look at the total value of the organization, take yourself out of the equation, and that's your value. So here's my value. I found 20%. Found 20% in 6 months. How did I do that? So we have a feed. Anybody who wants an e-discovery service, this is true at most firms. You know, they haven't built a SharePoint application yet. That's coming. They send a note. And I just looked for 6 weeks. I looked at what's coming across the feed. Okay, what were the top 3 items? Just, you know, throw it out there. What do you think the top 3 items? So e-discovery is the process of finding evidence. What do you think the top 3 things were? No. Can you reset my password? I forgot. Number 1, guess what percentage of requests that was? 8%. 8% of the total requests. I've forgotten my password. Can you reset it? I need to do something. Okay? Second request. There's a document in the database, but it's really 2 things, and I need to just, you know, tag a portion of it. Can you take the document out and split the document up into its constituent parts? Right? So there's an agreement with 17 schedules. They want the agreement and the 17 schedules broken up. Percentage of requests? 7% of the requests. And then there was another pretty simple administrative thing that was another 4% of the requests. So you've got 19% of the requests coming into billable people that are functionally unbillable. Right? Functionally unbillable, or that's going to be written down. So Google goes to all its employees and says, hey, take 20% of your work week. Take 1 day a week to dream, to imagine, to innovate. And we say, hey, take 20% and do these totally routine administrative tasks that could be automated that add marginal value. Very easy to fix those 3 things, right? What do? You implement the sign-on with Active Directory. You do single sign-on. That problem disappears forever. That's what we're doing, right? And I have the opportunity to do that because I'm re-architecting the entire portfolio. Document splitting. We've implemented a rule effective April 30th. No more crappy databases. We're not going to put a single thing in a database that isn't properly unitized. We're training all the paralegals and lawyers on the correct unitization. When you do correct unitization, you can do proper document categorization and classification. You automatically improve the searchability of your artifacts, right? That's really what you're doing, is you've automatically improved the searchability, which eliminates the 3rd redundant task, which is, I've lost this thing. Can you search for it? But we've got no fields. We can't search. We're sorting. Okay, that's the 4th thing. We find 20%. What do you think that's going to do to the bottom line of my department? I'm going to guess it's going to go up, right? I'm going to guess it's going to go up. So that's the type of work that I do, which is why I consider myself to be a re-engineer. We've just stopped doing 3 of the things that occupied 20% of our time. And we can focus on value. So a lot of what I want to talk about and a lot of the work that I want to do is to talk about defining problems in new ways. Because if we can take the existing marketplace and define the problems in new ways, we can see new opportunities to both help people and make money. So I'm highly motivated by helping people, but a lot of you are motivated by finding new sources of revenue, and whatever you're doing, that's good. I don't care what motivates you, I care about the result, which is why I like helping people. So I want to kick off a bit of a discussion, because we're all here in the law space, right? But do we have a common understanding of what that is? What is this law space? What are we talking about? Law is storytelling. And that's obvious when we talk about litigation, right? You know, you see all those dramas in the courtroom, storytelling. Even corporate law is storytelling. We're telling stories about arrangements. We're telling stories about allocation of risk. We're telling stories about rights, all of which are social contracts. Stories. It's all about stories. What do lawyers do? They tell stories, and they tell very powerful stories that become social contracts and social cohesion. Now, I'm getting really, really, really high up there, but this actually helps me understand what I'm doing every day. When I understand that what we're doing is telling stories, I can tell different stories, and I can find new channels of value, and I can find new channels of doing things. It helps you understand where the problems might be, okay? So this is why I move a lot of cheese, because I just think about things very differently. Okay, then there's two kinds of stories we can tell, right? Two kinds of stories. We're human beings. We're in 3D with a fourth dimension. We can tell stories about what happened in the past. We can tell stories about what's going to happen next, what's happening now, what's going to happen next. Who tells stories about what happened in the past? What kind of lawyers are those? Litigators, right? Who tells stories about what's happening now and what's going to happen in the future? Transactional, right? Two different kinds of stories. And then there's governments which tell stories, you know, they can change the rules about the storytelling. You know, sometimes they can make things retroactive, but they tend not to. They're usually transactional lawyers as well, just on a larger scale. And what kind of stories can we tell? There's sort of three archetypes of stories, right? There's stories about people and other people, individual stories. Stories about family law, right? There's stories about the individual and organizations, right? A lot of commercial law, organization to organization. These are fictional people. And then there's stories about the state and people. And then there's stories about state to state. But as we've just discovered, those are international and comparative lawyers, and there's no work for them, okay? So those are the kind of stories that can be told. And perhaps I'm getting a little bit theoretical, but I found that framework to be very helpful. If you understand the channels that are available to you, again, you can try and understand what potential problems exist. Another way that I like to say it is, do you have an acute problem or do you have a chronic problem? Do you have an acute problem or do you have a chronic problem? That's another way. And as a business person, you want to know if it's an acute problem or a chronic problem, because that's going to describe your revenue model. An acute problem, probably price insensitive, right? For an individual faced with a criminal charge, probably price insensitive. Okay? And that's why in the chart that we saw before, that was in the lower left hand of the corner. Sometimes the person just can't pay, right? Sometimes the person just can't pay, and that's why we've got legal aid. But there's a lot of other ways we can reframe that problem. Some things are chronic problems, okay? Collections, great chronic problem. So this is why individuals and organizations are different. Most people experience acute problems. Very few individuals experience chronic problems. So the only way to deal, like, you have to then find commonalities among acute problems in order to get scale. Okay, airplane claims is a great one. So if you're going to move into the individual segment, you've got to find problems that exist from person to person, otherwise you're doing bespoke work, and you have to organize yourself a little bit differently around that. Organizations and governments tend to have chronic problems as well as acute problems. Okay? The chronic problems tend to be closely aligned with operational dimensions. Okay? Collections. Okay? And so I give you this framework. I offer this framework to you so that you can start looking at the world to see and seize opportunities, much like, I think that's a great example with the airlines, right? A single thing, $600, nobody's going to file a claim unless you make it easy for them. That's found money for those individuals, right? That's why people are going to introduce a claim. It's found money. I didn't have 400 pounds today, but I'm going to have 400 pounds tomorrow if I click on this website. That's pretty enticing for an individual, right? That's incentivizing. And if you gamify that, wow, does that make it even more interesting? Right? So that's the next way to gamify. Like you start to gamify those things and then it becomes very, very interesting. And you can apply arbitrage and hedge to all of that. So I'm offering this to you so that you see the world differently, because I see a lot of things, and I have some comments about this whole new law movement, is that mostly what we've done so far is do wage arbitrage, and I think wage arbitrage has been effective, but it's a dead end. At the end of the day, it's a dead end for us if we ourselves want to make money, right? We're literally taking money out of our own pockets or out of our neighbors' pockets, which sometimes is effective, but I just don't know, as a coherent, cohesive community, that should be our primary mode of attack. What I think is going to be more helpful is if we truly innovate. And innovation really isn't copying what somebody else does. It's finding something brand new. It's going to Peter Thiel's 0 to 1. That's true innovation, is seeing the world in a different way. So that's why I present you my taxonomy of where law happens, because I've seen this, but you guys are smarter than me at finding problems and developing solutions to those problems. So please find new problems and new solutions. Another effective thing to consider is who consumes law. So that's the first question, but let's dig down into law a little bit better. So we've learned that law is storytelling, but let's go to the entertainment industry, because we all recognize the entertainment industry is about storytelling, right? Whether it's through dance or music or whatever. What are the different ways we can consume stories in the entertainment industry? Film. Okay, film, yep. And so film is interesting because film is a product, right? You can't consume a live film. Unlike a play. Play is live, right? So that's an important distinction. We're going to come back to that. This whole entertainment thing is an imperfect model, so we'll keep on going in, but you'll find the difference. So film is one. How else can we consume stories? We read them in a book, right? A book is a product. But, pardon? Music. Music is a great example because music can be a product and it can also be a service, which is an entertainment. You can go to a live band, right? We all know that listening to the band is not the same as seeing the band, right? So that's what I like about that, right? Music is a product and a service. So law currently is a product and a service. So I'm gonna point out Gail, who's the editor of a whole bunch of fabulous products in the legal services industry, who works at a publisher, and we all recognize that publishers produce products, right? A lot of what I find disingenuous about the new law movement is that our horizon is too short. So we criticize the billable model, but we've never thought about why we have that billable model. Why do we have the billable model? Where did it come from? When was it introduced and why? Does anybody know this history?
1906 or 09.
Yeah, so yes, it was introduced in about, I think 1906. And when was it introduced at large, right, in the late 60s, after, right? So the Cravath started it, right? Cravath started it, and like, you're right, like it was definitely pre-First World War. But why did everybody else adopt it, right? Cravath was quick, and it had a long time before there were a substantial number of followers. It was after an investigation into...
They wanted to see why bills were what they were. They were sick of having it be...
Right, so there was concern about price fixing in the industry, right? Because law is a closed shop, right? Anybody who's a lawyer, you benefit from this being a closed shop. You benefit from regulation. As much as we dislike our regulators, we have a monopoly. We have a monopoly, which is kind of awesome if you benefit from the monopoly. It's not kind of awesome if you don't benefit from the monopoly. So that's what we're fighting about when we talk about ABS. Right? We're talking about the pie and who gets to divide up the pie. And what a lot of happening now is the pie's just shifted. The cheese is moving. Cheese is running all over the place. So it was actually after an investigation, because bills just used to be $2,000 for services rendered. There was an investigation into price fixing and collusion among larger legal services providers, which at the time were probably 10-person law firms, right? You know, you think about it now and it's kind of funny. So that's why everybody went to the billable model, to break down that $2,000 for services rendered. I think it's hysterical that now what we're doing is we're going back to fixed fees for services rendered. I actually think that's hysterical. But that's actually what it used to be. The gown, does anybody know why there's that weird thing that goes over the back of the gown? Does anybody know what that is? So it's a throwback to? Yeah, the barrister's pouch. And how did that used to happen, right? The barrister used to sit at the bar, solicitor would put things in, and when would the barrister stand up?
Only when the money was in the pocket.
And it felt heavy enough, right? When it felt heavy enough. So there's all kinds of fantastic stories about the barrister just sitting there until the pouch felt heavy enough for them to go up to the bar, right? And remember, at the time, being a barrister was a gentleman's profession. Those men didn't need the money, so they could do it on a blind basis. So that's where we come out of. And that world, I don't know, that world just doesn't exist anymore, but it's kind of awesome to read about. I want to take you back to another throwback, which I think enhances your understanding of why I think this way. So I grew up at Blake's. It's an interesting place to work, like all big firms. It has its own culture rooted in Canadian colonial history, very, very much so. But Blake's has one really awesome thing, and what is that? Okay? One of the Blake brothers became an MP in the UK back in the colonial days, and he used to go in the boat, go across the ocean, and what he'd do is he'd buy all these law reporters and send them back to his brother, and they're actually annotated. They're actually awesome. And because I'm a nerd, I used to spend Friday and Saturday nights at Blake's reading all those old law reporters. And they go back to like the 1500s. They go basically back to the Guttenberg Press, which made me realize people talk about how there's been no innovation in law since the 1930s. That's not true. There's been no innovation, marginal innovation in law since the invention of the Guttenberg Press until the internet. But why is that? Because law is an industry based on stories. So the availability of communication channels is integral to the delivery of legal services. Communications technology and legal services are actually embodied together. And how do we know that? How many people have heard of the Hammurabi Code? How many people have heard of the Civil Code? It's because laws exist in writing. Our common law is based on writing in statutes and in stories that the judges tell. So people talk about access to justice, people not being able to get into the courts as being the greatest challenge to law. I say that's not the greatest challenge to law. The greatest challenge to law that we have right now is judges not issuing decisions, not telling our stories. Our generation is not going to have stories that reflect our values. The people who are disenfranchised, who can't get into court, their stories are not going to get told. What are going to be the stories about our generation? Large company stories. Law at an individual scale is disappearing. And if you think about it, that's what drives me. And I think that's a bit of what's been lost in the new law movement and in the access to justice movement, is a lack of focus on stories. So I do agree that this is all about business. But I think finding ways to tell those stories is very important. So I agree that businesses need stories to be told about their derivative contracts and all kinds of stuff, because that's how money and capital is organized in our society. But it's the absence of stories at an individual scale, which is, I find, a distressing proposition. Let's talk about the product to service to function to foundation framework as well, because I think this is another intersection which is hugely interesting. So the first thing to go to a commoditized level was actually the product, okay? Was actually the product, the book, okay? When justice would no longer be delivered by the king's guy going into the village and sorting out the fights in the village. And, and that eventually merged in the common law, the courts of common law and equity eventually merged. Took 300 years, right? It actually took 300 years for that. It didn't happen in Canada until I think 1878 or something like that, the merger of courts of equity. Those stories finally got written down. Those equity stories got written down in the same books as the common law. So that was the first one. And then we saw publishers, books, law reports, decided judgments, right? So if we actually think about it, that was an extremely important development in law, the commoditization of the product. Those are incredibly profitable lines. I mean, just ask LexisNexis and Thomson. They have basically a monopoly. And they now have such a fantastic infrastructure that I don't know how a startup is going to go and collect that body of information. The more important thing that happened, though, is Halsbury's, or key, taxonomy. They brought order to that system. So I went to law school early enough that I was taught Halsbury's, because I was taught how to do research in paper, because the legal online stuff, it just wasn't there yet. It just wasn't there.
And we call that shepherdizing.
Yeah, right? Yeah, shepherdizing and all of that kind of stuff. So learning how to stuff, but you had to know the overall taxonomy of law, agency, subcategory, order, right? So why did Ross go to legal research first? Because there's actually a repository of taxonomized information, right? You guys, the Ross guys? That's why you went there, right? Because there's actually an effective database. The problem with going there is that it's solving a problem that nobody has, right? Nobody has that problem because that system's been ordered for a long time. The problem that everybody's having is with all the good stuff trapped in emails and in documents. And everybody knows, in Canada, there's no one online repository for court filings. And if there is one, it's starting to be developed by Lexis and Thompson, again, not public. And for law firms, even sole practitioners have got it all trapped in their documents, which is why whenever you work in a law firm, you have the fabulous knowledge management system of, hey, has anybody dealt with this problem? If you have, give me a call. Awesome. Yeah.
That's the email that goes around when
Yeah.
somebody wants to see something.
It's awesome. And so, I do e-discovery, right? So sometimes I get my entertainment by taking my own email out of my system and sticking it in one of these things and doing visualization on the number of pardon the interruptions. In fact, that's often how I create the business case for, that is how I've created the business case a couple of times, is I've gone and done e-discovery on the law firm and said, hey, look at what percentage of our emails are X, Y, and Z. I move a lot of cheese, right? Move a lot of cheese. So there are some fantastic opportunities that lie lurking in the surface. And if you think about individuals, the problem that most individuals have is they have no taxonomy to describe their problem until a crisis event happens, right? Somebody dies, they get divorced, they run out of money, and they can't pay their bills. Individuals have no way of expressing their legal problems because life doesn't come at you, Now you're having a standard of care issue, and now you're having a duty of care. I mean, people don't think that way. That's a weird way to think about the world, right? You get trained like that. So I think a great product that could be developed is helping individuals see and recognize what problems they have and connecting them into the right legal service. That's a great product. Organizations have a very good sense of what legal problems they have. They just can't organize their information to get access to those problems. If you think about what e-discovery is not a legal problem. E-discovery is a problem that law invented in order to make money, which it was actually brilliant. But e-discovery is just this. E-discovery is just this, right? And a fantastic gray-beard lawyer, Silk, said this to me. He just said, I'm so frustrated by a modern practice of law. He's a trial lawyer, great trial lawyer. He's like, back when I started, you could just go to the client, ask for the underwriting documents, and a clerk would walk it over, okay? And that's true, because they used to go to the filing cabinet, they used to go to the shelf, they used to take the Redwell, they used to give it to you, but that doesn't happen anymore. So this is why I've been saying for a decade, e-discovery is expensing through litigation a failure to capitalize information governance, right? That's all it is. If you could just go to your client and say, just give me the 6 emails on this topic, the e-discovery industry would actually disappear. It would go away. It would just go away. And then you'd give those 6 emails to your attorneys, and they just start inventing a story about it, which is why my new mantra is just, what do I do? I organize evidence. It's inventory control. All I do is inventory control. That's actually what I do, inventory control. At my last law firm, we got to the point, it took 3 years, and it was kind of horrible. But if I saw any printout, because of the code that I would put on that document on the lower right-hand side, I could tell you what database that came out of, which meant I could identify whether it was produced, who it was produced to and when, how that data was processed, where it came from, when it was loaded into the database, and where's the disk of original information. Total evidence management for anything that came in after a certain date, right? Historical stuff couldn't do anything to clean that up. Why did I do that? What was the most influential thing for my decision that actually law firms had to get their hands around inventory management? It was 9/11. 9/11. So I was at the Court of Appeal on 9/11. And it was distressing to suddenly get the Court of Appeal shut down and airplanes were flying at the city. If anybody was in Toronto, you'll remember that day because all of a sudden you looked up and there were hundreds of planes flying towards Toronto and you were like, what's going on? This is pretty scary. But I walked back to the law firm and the buildings were, people had just exited the buildings. And I thought, what if one of those buildings fell down? And I was at a law firm. I was like, I'm just in the Court of Appeal, so I have my material. So let's just go back to this. I'll stop my 9/11 story. You can ask me about that. 3 things: products, services, functions, foundations. Legal function, what is that? A function, negotiating, mediating, resolving disputes. Foundations, dispute resolution enterprises. There is phenomenal money to be made in those things. So we're focusing on services, and I think Richard Susskind is great, but a lot of his books are really focused on services because that's where we are in the world in terms of our maturity model. If you want to jump 2-3 generations ahead, focus on functions and on foundations. Because if you can get ahead on a function or a foundation, you can control the market in that area because the rest of the market is not there yet.
So when you say function and foundation, can you just?
So for example, our court system is a foundation. Currently, our courts, or up until recently, our courts had a monopoly on dispute resolution. So all of this online dispute resolution or the stuff that's happening with PayPal, if they could scale that, tremendously, tremendously helpful, right? There's now systems out there, which I've experimented with. They're not quite ready to, they weren't ready to go when I was experimenting, but on online mediation systems, right? That's a function. Mediation, negotiation, a function. Or if you could just strip negotiation right out, or strip dispute resolution right out, suddenly you've captured both a function and a foundation. So one of the things that I'm excited about are certain types of contracts which could be available to be implemented through the blockchain technology. You've just removed negotiation and dispute resolution right out of those. You've jumped 2 or 3 generations right into a foundation.
So foundation is a.
It's like a systematic way of delivering the law, a systematic way. So if you think about it, if law is storytelling, a systematic way to capture the story, that's what that is. So if, pardon? That's what I'm talking about. A computational contract suddenly strips dispute resolution out. But what does it do? It creates new channels for creating legal services, right? Because you take that and you both create the retrospective and the prospective story inside the new instrument. I think that's a fantastic and exciting thing. So I'm going to stop.